Look, I'm going to give you the lowdown on the Supreme Court decision on abortion. This is the reality, not the stuff you're seeing on social media and in the mainstream media, the reality. The Supreme Court of the United States ruled that pregnant women are no longer persons. They don't exist as persons in this country for 14th Amendment purposes. What do I mean by that? The court said that pregnant women don't have due process rights or equal protection rights. Well, what does that mean, due process and equal protection? It sounds like legal jargon, right? Well, it is. But here's the bottom line in terms of what those words mean. In 1868, when the 14th Amendment was adopted as part of our Constitution in this country, it gave certain very, very important rights to persons. Of course, women were persons, right? That's what you're thinking? You would be wrong. At that time in our history, persons included everybody but not women. Women were considered to exist only in private spaces, in the home. They weren't persons who had rights. Well, we fought back against that. We fought back hard because the 14th Amendment not only said women weren't persons with regard to due process and equal protection, it also said women didn't have the right to vote, because in the second section of the 14th Amendment, we the country gave the right to vote only to white men. The 15th Amendment gave the vote to black men, but both amendments together gave the vote to no women, period. So women fought back and said, if you're not going to put us in the Constitution, we'll put ourselves in the Constitution. And they fought for two amendments, two of their own amendments. One, the right to vote. We all know what happened with that. It eventually became the law in 1920. Women won suffrage. Immediately after we won the right to vote, we went back for basic equality, basic rights under the 14th Amendment. We basically said, we have to fix the 14th Amendment because it doesn't include us on the two most important rights that human beings have in this country, equal protection of the laws and due process. Due process is as basic as it gets. Due process speaks to the nature of rights being so important in civilized society that you cannot have a functioning democracy without them. Things like personal autonomy, bodily integrity, privacy, things that apply to people to ensure that they exist and have rights and power as people against the government, right? This is the only way you protect people from a tyrannical government. You give them rights. And the most fundamental right you can give them is the right to be let alone. That's called personal autonomy. The right to be let alone. The government can't touch you. The government can't control your body, your mind, your life, your privacy. The most fundamental of all rights. That's due process. That's the nature of autonomy. It's so fundamental that a democracy can't exist without it. What Justice Brandeis said in the late 1800s was, the right to be let alone is so basic to civilized democracy that you cannot have a functioning democracy without it. And it's so basic, so fundamental that we don't want to put it in writing. We don't want to put the right to be let alone in the Constitution, lest people believe that because it's in writing, it can be interpreted and misconstrued and perhaps weakened. It was so fundamental that Justice Brandeis said it's not in the Constitution in its text because it's too basic to put in writing. That is the right that pregnant women lost from the Supreme Court last month. The notion that you have a right to be let alone, that the government can't tell you what to do with your body. Everybody else, and what I mean by that is men, continue to have the right to be let alone as that same fundamental right that Justice Brandeis talked about a very long time ago. And yet the Supreme Court of the United States said the reason pregnant women don't have that right anymore is because it's not explicit in the Constitution. You see where I'm going with this? Justice Brandeis said you shouldn't put it in there in a textual sense because that would debase it. But Justice Alito and his buddies said, well, because it's not in there, it doesn't exist. It's craziness because the right to be let alone, the right to personal autonomy, has been recognized by the United States Supreme Court in many, many decisions over the years, including something simple like you can't be forced to take medicine that you don't want. You can't be forced to submit to a surgery that you don't want. If you want, your body may need surgery, but if you don't want the surgery, you get to choose to not have it. I mean, that's how basic this right is. That's just one example. The nature of autonomy really applies to almost anything you can think of that establishes human beings as being important because we control the government, right? That's at least the point of a democracy, is we the people get to create, establish, and then authorize the government to have power and force against us. So you can't tell people that they don't exist as persons in a democracy where if they don't exist, then they're not part of the government that they created for the purpose of giving the government the authority to establish rules that we agree to abide. I mean, basically, we've just erased pregnant women from the Constitution on that very basic principle. That's how outrageous this decision is. Now, you might think abortion is not a great rule, it's not a great right to have. You might disagree with it entirely because you think the unborn is important, and that's fine. For you, you balance the state's interest in the unborn against the fundamental rights of women who become pregnant. They don't win automatically, perhaps, right? So you balance the woman's fundamental right to autonomous control over her body against the state's interest in protecting the fetus. That's fine. You have a balancing that goes on there. What you can't do is take women completely off the balance. In Roe versus Wade, women were on the balance, right? We were high up on the balance, actually. We had a lot of weight on the balance as against the interests the state had in protecting the fetus. We had about 90% weight. That's a lot. Like, women were considered persons, therefore they had a very heavy value when you pitted women against the state's interest in the unborn in Roe versus Wade. The unborn had a relatively low amount of weight. The state had a low amount of weight in protecting the unborn. And that was intentional. That was meant to basically say already grown adult women have a lot more rights than fetuses that aren't yet persons. That changed in 1992. So that was 1973. That changed in 1992 when the Supreme Court decided Planned Parenthood versus Casey. They bumped the weight of women's rights down from about 90% to about 70%. The interest of the fetus still mattered and was considered, important. The state could regulate in certain circumstances, and in that sense, weaken the competing rights of women over their bodies. But there was at least a balance. Flash ahead to 2022, and the Supreme Court completely took women off the scale, completely erased them from the scale. They have zero weight on the scale. They're not persons anymore. This is a flashback to 1868, except for the fact that, remember I said women weren't persons under the law in 1868. Well, we did become persons under the 14th Amendment. We became persons with second-class rights, but we became persons in 1971 when the Supreme Court decided Reed versus Reed. That was the first time the Supreme Court said, oh, hell, fine, we'll let women be persons. It was 100 years. We went from not being persons at all in 1868 to persons in 1971, but the court said we only had second-class personhood, so our rights were weak compared to other people's rights. But they still existed, right? We still at least had something from 1971. That was followed by Roe in 73, Planned Parenthood in 92, and then, of course, Dobbs in 2022. And what Dobbs did was it took us back not to 1971 when we had personhood, but only very meager personhood. It took us back to 1868. Non-persons. That's what pregnant women are now under the 14th Amendment. Non-persons with no due process rights at all. Everybody else in the country has due process rights. Everybody, but not pregnant women. That's how devastatingly outrageous this decision is. And never mind all this nonsense about, well, we're going to let, our states figure it out, and we're going to protect them. We're going to help women cross state lines and go get abortions, and we're going to make sure women have the funding they need to get abortions. No, 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 no. Because if that's your focus, that you're just going to help women function in their subjugation, in their non-existence, you're just going to help them do what they need to do as non-persons, then you're part of the problem. You are part of the problem. You don't help slaves find clean socks. You get them freedom. And if you only help slaves get clean socks, you are indulging their enslavement. The solution to this nightmare is to rise up against the notion that any court, much less the highest court in the land, has authority to erase an entire class of people, in this case, pregnant women. They erased them from the Constitution. That is unacceptable, and you cannot fix that in the states. Congress cannot codify Roe versus Wade, not in a way that helps women. It can codify Roe for federal jurisdiction, so you can, it can help you get an abortion in a national park, but you can't codify Roe and have it apply to the states. That's not something Congress can do. Neither can Congress ban abortion. It can't. And don't go into the fear-mongering. Don't get lost in the fear-mongering. Congress can neither protect nor ban abortion rights in the states. So don't listen to that nonsense. The only solution when the United States